Good afternoon, viewers, and welcome this week to another episode of Insights from Expropriations Legal. I'm Esther, your host, and today we're going to be discussing something quite different and enlightening. On today's episode, we shall be discussing and enlightening ourselves on an interesting concept in international investment law, which relates to the actions of a country or a host state on foreign investments in its jurisdiction. This we call the concept of expropriation in international investment law. So what's the concept of expropriation? Expropriation really, in basic layman's terms, simply means the compulsory taking of the assets of foreign investors by the host states. So by expropriation, it's meant actually like the coercive appropriation by the state or a country of the private property of foreign investors within its jurisdictions through the means of some individual administrative measures. Well, in law parlance, expropriation is actually used interchangeably with the term taking. So the taking of a property by a state is actually commonly known as expropriation. And on the face of it, it's lawful because any sovereign state, and when we say sovereign state now, to make us understand better, we're talking about a particular jurisdiction, a country, a nation. So when I refer to host state in this discourse, we're actually talking about the country in which the foreign investment is located. So the taking of property, expropriation of property, expropriation of the assets of foreign investors is actually lawful to a certain extent because the state has a right to control property and economic resources within its territory for the enhancement of objectives, be it economic, political, social, or otherwise. So there are grounds and circumstances where the expropriation of foreign investments can be lawful. So to fully understand the concept of expropriation, we may need to define some related terms before we delve further into the issues. First, who are private foreign investors? We've explained earlier that expropriation, when we were defining it, is the compulsory taking of the assets of the foreign investors by the host state. So who are the foreign investors in this case? They're foreign nationals, foreign companies in another state or country that have set up businesses in another jurisdiction, in another country, apart from their own country. So, take for instance, now we're in Nigeria at the moment. In Nigeria, we have a lot of foreign investors. There are companies that are coming from Germany, the United States, Bulgaria, different parts of the world to come and set up businesses in Nigeria. Those ones are foreign investors. Normally, under international investment law, the international investment law is actually designed to promote and protect the activities of private foreign investors, particularly in the host states. So really the rationale, behind international investment law as an area of law is actually to promote and protect foreign investments, within the host states, within the states where those businesses are located. When we say the state now, like I said, we're referring to the nation or the country where businesses are located. So this does not necessarily exclude the protection of government-controlled entities. So there are some foreign businesses that are government-controlled. I'll take, for instance, maybe the German government, for instance, just using as an example, goes to another jurisdiction to set up a business there. Yes, even though it's the Federal Republic of Germany that owns that business, they are still foreign investors in that locality, as long as they are not within their own territory. So, foreign investors could be individuals, they could be companies. in most cases, when in international investment law, in most cases, most reference to foreign investors are really to companies, because you discover that, yes, individuals do set up businesses, but a lot of times they set up business in their juridical capacity as juristic persons. So investors are either individuals, natural persons like you, me, individuals, people you can say like Mr. A and Mr. B, or companies being juristic persons. In the majority of cases of investment disputes, the investor has always been, most of the time, companies, that have juristic personalities. Though sometimes individuals can act as investors in investment disputes. So the foreignness, choosing that word carefully, the foreignness of the investment is determined by the investor's nationality. So what makes the investment foreign is the nationality of that investor. So if the company is owned and controlled by Germans, I'm using Germany now, just randomly as an example. If the company or business located in Nigeria is owned by Germans, for instance, then that company is a foreign investment in Nigeria. So the investor's nationality actually determines, to a large extent, whether that investment is foreign or not. In addition, the investor's nationality determines from which treaties that investment may benefit. So the origin of the investment, especially where the capital came from, where the money that they used to set up the business came from, is not a decisive question of the existence of foreign investment. So the fact that they brought in the money, let's say from Germany, or the bulk of the capital from the United States, does not mean that that investment is a foreign investment. No. What actually determines foreign investment in most cases is the nationality of the investors. And the nationality of the investors also determine what type of treaty the investors will benefit from. So, we now going, to also clarify properly again, what the host state means. So the sovereign state or country into which an investment is made is actually what we refer to as the host state. And that is, like we said, could be the country, the nation, as long as it's not the natural jurisdiction of the investor. So secondly, what is investment under international investment law? So different definitions have been attributed to the term investment, and this is relative actually from case to case. Some have defined investment as meaning every kind of investment in the territory of one party, owned or controlled directly or indirectly by nationals or companies of the other party, such as equity, debts, service investment contracts. So an investment, as long as it's in the territory of one party and owned and controlled by another national or companies of another country, in international investment law, that's definitely foreign investment. What are bilateral investment treaties? Because we're going to be referring to some of these terms as we go on. Bilateral investment treaties are actually international agreements establishing the terms and conditions for private investment by nationals and companies of one state in another state. So, for instance, United States of America has a bilateral investment treaty with Nigeria, normally, ideally. So most of the United Nations members actually have bilateral investment treaties with each other, so which gives their nationals the opportunity to come and invest in another state that is also a member, of that bilateral investment treaty. So when companies, that's what makes ease of international trade really, because a United States company, Google for instance, comes into Nigeria, comes and invests in Nigeria. They are foreign investors there, but they are protected really, and they are enjoying the treaty between the United States and America. So the bilateral investment treaties, which we call the BITs, BITs. They are actually international agreements establishing the terms and conditions for private investments by nationals and companies of one state in another state. So moving forward, we're going to actually be delving more now into what expropriation really is. But before we open up to a large extent, the concept of expropriation, we need to state and actually explain some technicalities between expropriation and nationalization. Because a lot of countries, even in practice, you see, they tell you that, okay, the companies, the country, the host state has nationalized, some sector of the economy. So what does nationalization mean? How does it differ from expropriation? So an expropriation, like we have said, is the taking of private property by a government acting in its sovereign capacity. Because yes, it's within its jurisdiction, it has a right, of course, under natural justice, not against public policy, to determine certain things that happen within its jurisdiction, certain things that happen within the economy of its jurisdiction. And nationalization, it's a form of expropriation, yes, but it generally covers an entire industry or a geographic region. So it's something that is, when nationalization comes in, is targeted towards a particular sector. Different from the random taking of assets, that expropriation could cover. So nationalizations typically occur in the context of a major social, political, or economic change. So let's take, for instance, Nigerian government decides that the educational sector, for instance, they want to nationalize it. That they don't want any foreign investors coming in. The government wants to take it over and want to make sure that it's only Nigerians that are in the educational sector and that can establish, the educational sector in Nigeria. Then that sector has been nationalized. It's different, in a bit from expropriation, where it could be random and is not really targeted towards a particular sector. So nationalizations do not differ in substance from expropriation. However, they are directly statutorily based, and they have a wide coverage targeted towards a sector, an entire industry, a geographic region. When a state involves in nationalization, it will focus on a sector or an industry to take over. So what's this concept of taking or expropriation, as we'll call it under investment law? There have been attempts by different scholars, legal texts, arbitral tribunals, investment dispute tribunals, to define what actually constitutes a taking of property or expropriation of property by the host state or by the government of a particular jurisdiction. So under Article 3 of the 1997 OECD Draft Convention on the Protection of Foreign Property, a measure that led to deprive ultimately the alien, when they say the alien now, the foreign investor, of the enjoyment or value of his property without any specific act being identified as outright deprivation. That could mean expropriation. So the Article 3 of the 1967 OECD Draft Convention, which is a convention to protect foreign property, defines expropriation as a measure that leads to depriving ultimately the foreign investor of the enjoyment or value of his property without any specific act being identifiable as outright deprivation. So as instances, may be quoted: excessive or arbitrary taxation, prohibition of dividend distribution coupled with compulsory loans, imposition of administrators, prohibition of dismissal of staff, refusal of access to raw materials or essential export or import licenses. So now I will explain that. the host states can actually put in different measures, whether directly or indirectly, to take over the assets of the foreign investors within its jurisdiction. For instance, they impose arbitrary taxation on that company. To a large extent, that's a measure of expropriation. They prohibit dividend distribution and say, okay, your company cannot distribute dividend. They impose administrators maybe to take over the assets of the company. Yes, there will be reasons why they're doing that, and we're still going to come to the circumstances that actually leads to expropriation. But these are measures, that when it happens, it could be termed that the government or the host state is actually expropriating the assets of that foreign investor within its jurisdiction. So direct expropriation involves the actual taking of property by the host state by direct means. So it could mean the loss of all control by the foreign investor of his property, or almost all the useful control of the property. So the government of the host state could decide that, okay, they're going to take part of the control of the foreign company from the original owners. So in such a way that they are not really the ones fully in control anymore, and they cannot really enjoy, the value that they are supposed to enjoy to that asset. Then that means expropriation has occurred in such instances. So the Central American Free Trade Agreement, which we know as CAFTA, defines direct expropriation as a situation where an investment is nationalized. Now nationalization is coming in, or otherwise directly expropriated through formal transfer of title or outright seizure. So the government of the state could outrightly seize the assets of the foreign investor, or the transfer title of the foreign investor maybe to the host state or to some other persons designated by the host state. So it is undisputed, that international law permits the expropriation of the property of foreign investors under certain circumstances. So definitely in international investment law, expropriation of property of foreign investors is definitely allowed, but under certain circumstances. In our contemporary times, direct expropriation is actually fading away. Now, states are looking for ways indirectly to take over assets of foreign investors without actually making it look as if they are taking over the assets. And that is what we call indirect expropriation. This is a serious area, really, in international law, because a lot of governments has actually indirectly expropriated, taking over the assets of the foreign investors in their jurisdiction without actually doing it directly, but they've done it indirectly. And we're going to look at some of these issues. So we see that because states don't want to jeopardize the investment environment, they will not come out openly to say they are taking over the foreign assets, the foreign investors. But they'll find a way to indirectly take over those assets. So classically, ideally, takings should involve the direct seizure of the physical assets of the foreign investor. And identifying this kind of expropriation is very easy because the government just takes over and that's it. But what's difficult really in investment law when it comes to expropriation is how do you identify indirect expropriation? So expropriation could be by indirect taking, it could be by direct taking, and it could also be by what we call something tantamount to taking. We're going to get to that. These days, expropriation occurs in different ways now, not necessarily directly. So a lot of old states, they interfere with the rights of the foreign investor without a formal taking of the title. So the company, let's say for instance Google in Nigeria now, Nigerian government wants to indirectly expropriate Google as a foreign investor in Nigeria, the company Google. They'll do it in a way, it's not as if they're going to pass over title to them, but certain measures that they take, maybe they take over the board of the company, they impose certain things, measures on the company, they are indirectly taking over the title, the assets, the value of that company from the original owners. What measures could be considered as indirect expropriation? We are going to actually explain that in detail a bit as we move on. So there are certain requirements for legality of an expropriation. Don't forget when we were talking earlier, we said that international law legalizes expropriation in certain circumstances. Certain requirements has to be met by the host state for an expropriation to be legal. So you discover that if these requirements that we're going to list now, if they are not identified in the kind of expropriation that occurs, it could actually be disputed by the foreign investor, and the foreign investor can actually take this host state to court. So you see a lot of foreign investment disputes, you know, in ICSI tribunals where investors take the host state to court on the issue of expropriation. Most of the time is an issue of maybe the host state actually was arbitrary in its measure. And so we need to make sure that these requirements are actually properly identified to make an expropriation legal. So an expropriation, for it to be legal, is not going to be discriminatory against the investor. So it's not going to be a case of, okay, yeah, the board of directors, for instance, maybe some of the board of directors of the foreign investor, they actually have issues. For instance, just using an example, maybe with a politician in the host state, and because of that, they just impose arbitrary measures on them until they're taking over their properties. Because of that, that is going to be discriminatory. So, for an expropriation to be legal, it's not going to be discriminatory against the investor. Secondly, it must be for a public purpose. So, before the host state can decide, okay, we want to take over the assets of this foreign investor, there must be a public purpose reason that will help the public interest of the host state. So it must be for a public purpose while they're expropriating. Thirdly, it must be in accordance with due process of law. So they have to do it in such a way that they take over the assets with due process. Not doing it anyhow, but properly following the due process of law. Fourthly, any legal expropriation must be accompanied by a prompt, adequate, and effective compensation. So if you're taking over the foreign assets of a foreign investor, within the assets of a foreign investor, rather, within the host state must adequately compensate that foreign investor before that expropriation could be legal. We'll give an instance in land law. You know, for instance, we might have heard about, there's something we call government acquisition. If a government identifies a land, yes, under land law, the government owns all the land. And yet they give certificate of occupancy to certain areas where people, individuals can buy, companies can buy, you know, and government will give the certificate of occupancy. However, there are certain areas that government will say, this is a government acquired area and they need it. In such kind of cases, even where people are already living there, the government has a right to take over those lands, but they must compensate the owners, the people that are already residing in that land, or people who have already paid for that land previously. So in this case too, it's the same. You know, when we talk to investment, under investment law, when the assets of a foreign investor is being taken over by the host state, there should be adequate, and there must, ideally, be adequate compensation given to the foreign investor company or the foreign investor individual. So modern bilateral and multilateral investment treaties contain reference to indirect expropriation by protecting the investor from expropriation, as well as measures having an effect equivalent or tantamount to expropriation. So I'm just going to mention one of the articles, really in under the treaties. The North America Free Trade Agreement, which we called it after. If you look at the article 1110 sub 1, it actually states, amongst other things, that no party may directly or indirectly nationalize or expropriate an investment of an investor of another party in its territory, or take a measure tantamount to nationalization or expropriation of such an investment. So ideally, even though expropriation is legal, it should not be done arbitrarily. It can only be done under certain circumstances. Maybe it's like we mentioned, for public purpose, and there must be adequate compensation. It must be based on due process, and also it must not be discriminatory in nature. Issues affecting public health, for instance, the environment, general changes in the regulations, within the economy of a whole state, may prompt a state to regulate foreign investments within its territory. We should, bear it in mind that every country, they have a right, to regulate investments, whether foreign or local, in their jurisdiction. So if, for instance, a company is producing hard drugs and is affecting the health of the citizens of the state, the whole state has a right to take over that foreign investment. Even though, yes, it's boosting the economy of the state, but it's against the public health. Things are going to affect the environment. Changes in the regulatory policies may definitely prompt a whole state to regulate foreign investments within its territory. So based on various definitions, as we have said, on expropriation in investment treaties, so we can actually principally divide expropriation into three categories, which are direct taking, indirect taking, and another identity. In terms of category, the third one, there are actions that are tantamount to a taking or equivalent to a taking. So which means they are in between direct expropriation and indirect expropriation, depending on how you view it. So we've explained what a direct expropriation is, that the host state just openly says, we're taking over the title to this company, we're taking over the assets of these foreign investments. But indirect expropriation comes in different ways. It could be like, okay, a certain percentage of the assets they're taking over, or they're taking over the control of the board, or they're taking over they're not really taking over everything, in that sense, or not openly coming out to say they are taking over. That could be termed as an indirect expropriation. And most states these days indirectly take over because they want to try and protect their investment environment, and they don't want to make their country look hostile to foreign investors. So, moving forward, we're going to list out what actually constitutes indirect taking or indirect method of expropriation. Like I said, this is a very vague area, and it's a very serious area that up till now, researchers are still looking for a comprehensive doctrine to actually be able to categorically state measures and identify what could be established as indirect expropriation. However, diverse ways in which property interests could be affected, it makes the definition of indirect expropriation quite difficult. But some conventions, some treaties, some cases, scholars, some have tried, they have attempted, I'll say attempted, to define what indirect expropriation could mean. Under Article 10 sub 3 of the Harvard Draft Convention on International Responsibility of States for Injuries to Aliens, a lot of conventions, international conventions, use the word aliens, to replace foreign investors, It gives an insight into specific categories of indirect expropriation. So it's saying a taking of a property includes not only an outright taking of property, but also any such unreasonable interference, use, enjoyment, or disposal of property as to justify an interference that the owner thereof will not be able to use, enjoy, or dispose of the property. Yes, and not to bore you with the legal jargons, really. What this is actually explaining is the moment there's an interference to the foreign investment, an expropriation has actually occurred, whether directly or indirectly. So indirect expropriation involves a situation where the host state interferes with the rights of the foreign investor in the investment without a formal taking of title. So that should be actually be noted, because like I said, they are not actually coming out to say, oh yeah, we're taking over the assets of this company, and everybody knows. But there is a way that the host state will do it, that they will indirectly take over the assets of the foreign investor. So, according to a particular study, the United Nations study on taking of property, indirect expropriation may occur when measures short of an actual taking results in the effective loss of management, use or control, or a significant depreciation of the value of the foreign investor's assets. So, if a host state says we're diluting the management of the board of a particular foreign investor, a particular foreign company in his jurisdiction, it has actually interfered in the management of that foreign investor company. That could be tantamount to an indirect expropriation. If it takes over the control indirectly, if it depreciates the value of the foreign investor's assets within his jurisdiction, that could be indirect expropriation. So, that's a very interesting concept, really, because that means at times, all states also has to be very careful to make sure that they don't make their foreign investors start working on eggshells within their jurisdictions. And if they're not careful, if they don't do these things wisely, in terms of having the right policies, putting in the right laws, a lot of host states could lose foreign investments, which could boost their economy if they are actually very friendly. So arbitral decisions and academic literatures on foreign investments have identified the types of indirect taking that could amount to expropriation. Though the question, like I said, as to what actually amounts to indirect expropriation has really not been cogently, comprehensively answered up to today. It's still a search that is still going on. However, according to a scholar, circumstances that could lead to indirect expropriation could be grouped into the following. First, sales of property. So where the host state forces the foreign investor to sell off its property, that could be identified as an indirect expropriation. First, sales of shares in an investment through a corporate vehicle. So the host state could set up another company to take over the shares of a foreign investment company. That could be a form of expropriation indirectly. Indigenization measures. There are times, for instance, in Nigeria, I think in the 70s now, from decrees, indigenization decree 1972, 1977, Nigeria government actually indigenized some sectors and insisted that even if a foreign company comes into Nigeria and is set up here, Nigerian nationals should have a percentage shares in that company and should have a measure of control on the board of such companies. So those are indigenization measures. Taking over management control over the investment would also be tantamount to an indirect expropriation. Inducing others to take over the property physically could be indirect expropriation. Failure to provide protection when there is interference with the property of the foreign investor. So ordinarily, all states are meant to protect both their citizens and foreign nationals within their territory. But in a situation where the foreign investor assets is being depleted and the host state is doing nothing about it, definitely that could amount to an indirect expropriation. So that could mean that the host state is actually saying we want to take over, the property of the foreign investor. So administrative decisions also, which could cancel licenses, permits of the host state, or of the foreign investor within the host state, could amount to indirect expropriation. Because, take for instance, they give them license to produce, let's say they give them license to produce tobacco, for instance, and they're able to produce, they will produce. Next thing, the government decides they're not going to renew their license. Then definitely, something is going on there. And expropriation is actually happening indirectly, even though they are not coming out to tell them that, oh, we're taking over your assets. But these are, signals for the foreign investor. So exorbitant taxation on certain sectors, even under taxation law, really, there are instances where the government will impose more taxation on certain industries, to be able to discourage production in such industries. So exorbitant taxation could be on a particular sector, on a foreign investor, could mean an indirect expropriation by the host state. So expulsion of the foreign investor also from the territory of the host state, which is contrary to international law, could be tantamount to indirect expropriation. And acts of harassment, such as freezing the bank accounts, promoting strike, lockouts, labor shortages, for the foreign investor or company, are all acts that has been identified as indirect expropriation. So if a foreign company here in Nigeria, for instance, the government decides all the assets of the bank accounts of the company should be freezed, then something definitely, the Nigerian government is definitely trying to take over. That's what it means, So some of these things we've listed above are circumstances, instances, examples that have happened in real life, practical, that have made scholars, academics, judges, arbitrators, made them identify certain things that could be tantamount to indirect expropriation. So, to conclude, under international law, as we have said, it recognizes that states have rights to nationalize or expropriate, and that right is subject to certain conditions under the customary international law and investment treaties. And those conditions they have to be the legal requirements, for the expropriation to take place. So these conditions have led to a distinction between lawful and unlawful expropriations, like we have identified that the expropriation must not be arbitrary. The moment, and it must not be discriminatory. The moment it's discriminatory, then it's not lawful. And a lot of investment disputes, have even blamed and awarded penalties against certain host states for arbitrary expropriation. So indirect expropriation, we've identified that they do appear in multiplicity of cases. It's not a new concept now. A lot of host states now are indirectly, by the measures they are taking over the assets of foreign investors, even in their jurisdiction. So we have direct expropriation, which is the open taking, formal taking of the assets, and indirect expropriation by different measures put in place by the host state. So it's generally accepted that certain types of measures meted out by the host state that affects foreign property will be considered as expropriation, requiring compensation through the formal title, though the formal title of the foreign investor is retained. So they give compensation to the foreign investor because the host state is taking over the assets of the companies, the assets of the foreign investor. But there are times the foreign investor could still retain the formal title depending on the type of expropriation. At times the government host state take over the formal title directly, and that's it. There are times the foreign investor still owns that formal title, but the host state has taken over more of the control of the foreign investment. So what had been contentious, like we said, and is still drawing a lot of attention, in the legal world of investment law, is between what are the compensable regulatory takings. So what are the takings, expropriation, that should be compensated for? And what are the ones that the host state has a right not to compensate for. Those has to be identified. Yes, if the foreign investor company is involved in criminal acts, actions, productions, his business is against the public policy, then definitely if the whole state is taking over such kind of businesses or assets of the company, it may not necessarily compensate such investor for the takeover, because of course his business is actually not helping its economic environment in the first place. So there's still a lot yet to be answered on the search for a comprehensive doctrine on indirect expropriation and actions of the whole state that could amount to indirect expropriation. We'll be dealing with this in detail in an article that will come out, on our sites, on our pages, on our YouTube, on our LinkedIn channel as well, so that will enable our viewers who are interested in knowing more about this area to be able to understand better in detail, what various jurisdictions have said, what various cases have said. So we believe today we've been able to explain, to an extent, the concept of expropriation in international investment law. Till next week when we bring you another enlightening topic, we say have a blessed weekend. Thank you and God bless.